Happy Advocates Day to all. It's my immense, it's my immense pleasure that I have been given a chance to speak on the topic law, text, and purpose. This is, if we talk about the law, it has its own ramifications, it has its own facets. The first and foremost is the text. What is the text of law? Comprises of a series of texts that contains certain legal character and reason. A law, a legal text cannot be bereft of the reason, first of all. Second, it has to has a legal character. If you see the drafting we make as advocates in the courts, has a different legal character, has a different character altogether. If a layman just write out an application, it has its own format. We in the courts follow a different format. That is one of the facets of the text of law. The purpose of the text is especially to preserve, use, clarification, and formulation of rules. You see, when the text is in writing, we can go to the books and have a look onto the text itself and try to deduce from there what actually it means, what actually it tells us to follow and how to follow. We have a doctrine evolved that's called as equity follows law. When we talk about the doctrine of equity follows law, that means a, there is a certain kind of circumstance which the judge or a judicial officer is bound to follow. And that circumference is given to it by the legal text. It cannot evade or it cannot escape that bounds. Everything is to be done, even if he is to expound certain, just include certain ideas of himself in a particular case. Everything is to be done and governed by the legal text. For example, Civil Procedure Code, we talk about it governs the proceedings which are being held in the honorable courts, especially in the municipal court, this municipal courts and these lower judiciary. The judges are told that they are being bound by a procedure, certain set of procedure. That certain set of procedure, either in criminal, just criminal part of it or the civil part of it, is being given and provided by a certain text. That is the CPC in so far as the this civil part of it is concerned, and CRPC so far as its criminal part is concerned. But it cannot escape, just within the contours of this dimension, the principles set up by the procedure. When we talk about the legal texts, where we can find it, it's not only the statutes or the codes which are included in the definition of the legal text. It has it is something more than that. More than in a sense that constitutions around the world, the documents such as on these contracts, deeds, orders, judgments, decrees, pleadings, statutes, and many documents of legal character. They are included within the broad definition of this text, the legal text. It's very important as a lawyer. Now, what's my role? What's our role as a lawyer? How can we shape up this legal text? Of course, within our ambit is the assistance to the judicial officers in their deliverance in the courts. When they deliver the judgments, when they deliver the decrees, when they deliver the orders in the courts, it is obviously the advocates who are assisting them to reach to a certain conclusion. So the advocates have an immense role to play so far as the textual this part of the law is concerned. Of course, the statutory part of it is the domain of the legislators. It is the domain of parliamentarians. That that keeping aside that part of it, the character of the legal text is also within the domain of a lawyer, and a lawyer must try to inculcate, and imbue all the good, just techniques how to evolve and how to, just present his text before the before any authority. Now, question arises as regarding the interpretation of the law. Regarding the interpretation of the legal text, earlier in the 80s or the 90s, there was a doctrine followed throughout the world, especially in England, because we follow as the one of the colonies of the England. We follow the common law. Text is the same. It has its own amendments from here and there from time to time, but basically the theme is same. The law which has been evolved and laid down by Macaulay, we still follow that. We still follow the evidence that has been evolved by the courts or the legal system in UK. Therein especially was the plain meaning rule. What it means, what it connotes, plain meaning rule. It simply talks about the fact that a judge or an advocate should concern itself, especially just to the facets of a particular statute. If I just talk about or plead a case before any authority as an advocate, um, and it is covered by a certain provision of law, it says to me that you should contain yourself within the contours of that law. You cannot escape, or you cannot just try to just evade it. Similarly, it costed a duty upon the judges or the judicial officers to look into the fact that the the literal meaning, the a contextual ways to interpret the law. Textualism, the strong this advocate of at the present of the textualism is Justice Antonian Scalia. He is the Supreme Court judge in the United States. He is rather the proponent of the fact that when we stick to the text of the law, there is seldom any room for errors. He vehemently or talks about time and again, talks about that judge should restrain, or the advocate should restrain from experimenting with the law. Rather, they should stick themselves to the text of it. Now, the question arises, as advocates, how can we just in this modern era, uh, one of the facets of the modern era is the evolution of this computer and its just various branches. Say, for example, at present we talk about AI. One of the concepts is being evolved as an AI, artificial intelligence. How can we, just take advantage of these tools or these machines, so that we can benefit ourselves as lawyers, and to benefit ourselves to how can we assist the courts more, in a more pragmatic way. AI, if we talk about the AI, if AI concerns itself with the text part of the law, it cannot concern itself with the legal spirit, the spirit of law. It concerns about, but it has its own, it has its own role to play, an immense role to play as the one of the tools where we can find just many things. Say, for example, document analysis is a major part of our just legal any legal discovery. Document analysis, we can go to AI tools, say for example chat GPT, and we can make it to analyze a certain legal document for us. The simplification of the second one is the simplification of the legalese. Legalese means often we see the text incorporates a language which is not easy to understand for a common man. It has its own ways and means to express itself, and a common man or a layman cannot just experience what basically the text means. At in that eventuality, we can go to the AI, talk about it, and ask it what how can we simplify these legalese. It can expedite the due diligence process. It can make predictions of legal outcomes. What can be now the stage has come where we can ask the artificial intelligence what can be the possible outcome of a particular case, what can be the possible outcome of a particular event. So far as the law is concerned, it has its own intelligence, and it can just predict the scenario, what are the possibilities. And that part, these predictions of the either of the information technology or the webs or this what we call as these phones or the computers, is this that it once it is in textual form. If it's not in textual form, the no instrument has been so far developed by any person around the globe which can go to the spirit of a law, spirit of the law. It's only the humans and the human reasoning, which has made it possible that we go to the spirit of law, what basically and actually the law means. what what are the basic just benefits, what are the benefits of this text? This is one of the moot questions. The benefits are so many. One, say for example, it has a written text are more permanent in its character. Once it's in a book form, like I have this book before me, I can go to it at any time. It has its own permanency as law. We can evaluate law while going to the text. So it has a permanent character once it is in text. Second is the uniformity in application. Say for example, there are thousands and no, thousands of cases before the pending disposal before many courts around the world. I know, just keep it to my country only. Around the world, many thousands and thousands of cases. But once the text is there, oh, basic text is there which governs the trial of a particular case. It governs all uniformly. It gives a uniformity in its application to all the cases. It makes a judge to just apply the law in its uniformity.
Sir, kindly unmute your mic. Unmute your mic.
Am I audible, sir?
Yes, yes. Thank you. Thank you very much.
Was I just audible before?
Not few minutes before, but now it's audible now.
No, sir, we lost your audio, I think 15 seconds back. Now we can hear.
Okay, I was talking about the uniformity in its application. Once the text is there, the law is in its textual form. It gives law a uniformity in its application to different cases. Thousands of cases are pending disposal before different courts. But once the text is there and it uniformly applies to all, it makes the process of judiciary as just expeditious, and it makes it just, so that no one feels that a different sort of rules have been applied to my case and somebody will say that different sort of rules have been applied to his case, which is not the case. The application of law, the application of the code, the application of the basic substantive law is the same to each and every case. The third benefit of the legal text, is that Alignment of focus on part of the judicial officers. This is one of the important facets of the text, legal text. It allows the judicial officers, or for that matter the advocates, to understand and to just um, align themselves to a particular set of circumstances, and in those circumstances, and to apply the law in its uniformity to those circumstances. There is an alignment of this in the wisdom on part of the judicial officers, and of course the advocates have a greater role to play when they assist the honorable courts regarding these matters. Third, the fourth part of it is the text tends to be more planned rather than the spontaneity of speech. Now, say for example, I am talking before you, I'm addressing the august gathering of lawyers, and it's my immense pleasure. It's a spontaneous speech. I express my words in a different way at different times. There is no permanent character to my speech. I cannot plan my speech, or what I want to say. I cannot plan my lecture. This is the spontaneity. This uh, the application of the law does not need the spontaneity, rather than it needs a planned way to apply a particular law to a particular case. That's very important. That comes when the law is in the form of text. You know, when the law is being formulated, it gives an immense space to the legislators, or the lawmakers, for that matter, to foresee future contingencies. They can foresee what is going to happen, or what can be the future possibilities which may arise. They can just formulate the laws in that way, in that fashion. They can fashion the laws, they can fashion the statutes. Likewise, the judicial system becomes more expeditious once the uniformity is there, once the alignment of focus is there, once the contingency, just foreseeing of contingencies is there. Obviously the judicial system becomes more expeditious, the delivery of the justice becomes more expeditious, it becomes more deliverable. Just you cannot keep cases pending for years and years and years together. The permanency of law in its application is one of the facets, and the first and foremost of all is the repository of law. In terms of judicial precedents are the part of textual law. They are the very foundation of the textual law. Basically, the lawmakers give us a particular law within a certain, just the language of that law is within certain just circumscribed limits. Basically, it is the judges and the judicial precedents which rather than evolve the law and its application to the present scenario. So these are the various facets of the law. As lawyers, as advocates, we must try to just harness our the intellect, so far as the application of these textual part within our power is concerned. We must try our just try to inculcate the things which can be just which can help the judicial officers in their just deliverance of justice in the form of many things, just orders, for that matter, judgments, decrees. It is the basically, just behind every order, every this judgment or the decree, there is the wisdom of a lawyer, a painstaking wisdom of a lawyer. We must try to, just uh, uh, gild that. That is very important, and that is the duty cost upon a lawyer. As being in this legal profession, we must try to just chisel that out. Now, against this theory of textualism, there is another set of there are another set of just advocates who are being just worldwide referred as intentionalists or purposivists. What do they really mean by that? When we talk about the purpose of law, when we talk about the intention, they say their argument is that no text can have a meaning independent of the intentions of its makers. You know, when a lawmaker makes a law or a lawmaking authority makes a law, it cannot just cannot be just seeded from the intention of the legislators, what they intended to do or what they intended to draft this law for. That is the argument of the purposivist. That what is the purpose of law? What was the intention behind this law? They say the danger of textualism is that if judges interpret law strictly as per text, the intention behind the law may be missed, and that will cause more injustice. What their argument has been all through is that the the spirit of law, the intention of lawmakers is, if we just try to interpret every law strictly, that will just lead to more injustice, because every set of every case has its own set of facts. It is the duty of a judicial officer, it is the duty of a lawyer, of an advocate, to apply its wisdom to a particular set of facts and try to just try to carve out a path and try to find out. Say for example, I give an example regarding this. Say for example, the law has been legislated, this DV Act, Domestic Violence Act, for example. uh, the basic purport of the legal this act is that every household should get peace, calm. It's a social legislation, and there should be no the women should not be subject to any domestic violence. But there can be certain just instances when the allegations are incorrect, and ex facie they seem to be incorrect, whether we can apply, or the facts demand by themselves, they demand that the law is to be interpreted in a different way. At that time, it is the judicial wisdom, it is the wisdom and know of the lawyer, of a lawyer or judicial officer at the time, to see what is the purpose, basic purpose of this basic theme of the law. It cannot be applied keeping just by keeping blind your eyes blindfolded and apply the law strictly. The One of the examples is that, may I just I may go out of the context here, with the permission of all august gathering. uh, when Moses was sent to the people of Jerusalem, he was given 10 commandments, and those 10 commandments were the pure law, a law given to the people of Israel. Afterwards, it was felt by the circumstances, by nature, that these laws are being applied without the context, without their purpose, without going to the purpose, without going to their purpose. What was the basically the purpose of these laws? They are being applied blindfoldedly, strictly, and that leads to injustice rather than doing justice in the garb of those laws. Then came another prophet Jesus. He was told that the laws are the same, the 10 commandments, but I am here to give you the spirit of that law. And that spirit, that the Jesus, what spirit he came with, that is the purposism, the purpose, why it is necessary, why it has been inducted, what basically is meant by this, why a particular section has been kept here, what was the intention behind it. You know, the courts in India have applied these doctrines with this purposivism doctrine in many of the cases. One of the cases when just applying the doctrine of pith and substance in Prafula Kumar's case. Hello, am I audible?
Yes, sir. Yes, sir. You please continue. Some people join,
Yes.
they forget to mute their
Okay, okay,
audio.
okay, okay. No issues at all. You know, our apex court has, in many of the cases, just applied this doctrine of purposivism. The purposivism doctrine, one while applying the doctrine of pith and substance, the Privy Council, for that matter, in Prafula Kumar's case, said or laid down that it is a duty cast upon the courts to go to the object of law, the basic intention of the law. What was the basic intention behind passing of a particular legislation? If that legislation has a different intention, we cannot interpret it in a different way, or it cannot be given in a different color. The Honorable Supreme Court talked about this in Corrigal while talking about the Corrigal legislation in KCG Narayan's case. Different facts involved in different cases. If we, apply the law in its uniformity, that's why in under Article 14 of the Constitution of India, one of the doctrines was evolved is that doctrine of intelligible preference. This I forget that doctrine right now, but a doctrine was evolved where it was said a class within itself. We cannot apply the law in uniformity. We cannot apply it to each and every circumstance. If a law is made for a particular community, it cannot be applied to all because its intention, its purpose was for a different thing. A a barrister cannot appear in the medical examination, or he cannot demand his absorption in the medical field. For the matter, the laws governing on that subject are different. They talk about the different things. They talk about a different set of people and in a different context, different this intention. It has a different purpose. So there has been a tussle around between these two thoughts: purpose of the law and the text of law. If we talk about the purpose of setting up the family courts, family courts in the district court complex, what was the purpose behind that Family Courts Act? Why it has been set up? What for reason? For what reason? And what is the role of a lawyer in that court? First of all, the act talks about the lawyers do not have any uh, role to play in those courts, but the judicial officers allow the lawyers to come and assist them because the purpose of the law is is to facilitate the two parties, two contending parties, to come to a common to come to the common terms and try to just try to negotiate between these contending parties and to bring them on on a particular issue together. If the assistance is being asked by the judicial officers, it's the duty cast upon the lawyers to see what is the purpose behind it and try to find the middle path, that's called as eclectic path, in between the two extremes and try to bring the parties close. So this was broadly the aspect of the textualism and the purposivism. If you guys have any questions regarding this, I'm free and open.
So we will leave this floor open for questions. Anybody who wants to ask a question will raise a hand. Then we'll allow all the people who have to ask questions one by one. So, sir, till somebody raises his hand, I would ask the first question, sir.
Sure, please.
Once you talk of purposivism, how do you describe the method through which someone interpreting the law would understand the purpose of the statute. The reason being
Yes.
that there are different ways of interpreting it. You either take the historical approach, or what one can say, you go to the intention of the legislators. But the
Mhm.
problem with the intention of the legislators is that there are as many intentions as there are legislators. For example, in the Parliament of India, there are what 800 odd members of the Parliament. They would not think the same thing about the law when they are voting or for or against it. So, how does one go back to the intention of the legislature to understand the purpose of the law?
Exactly. You see, this aspect, just I was not able to, keep it in my lecture. 2 3 days back, I was watching a program. It was the appointment of judicial officers in the U.S. One of the senators, Kennedy, asked a question regarding specific question regarding the purposism. He asked a judicial officer. She was to be appointed as a as an one of the just aspirants to the Supreme Court judges. She was asked by the Kennedy specific question regarding the purpose. What do you mean by purpose wisdom? She said that the purpose of law and the intention behind, as I was explaining. Then he asked the purpose, intention of who, whether the maker of the law, the judge of the law, the the demand of the case, the demands of the society. It is rather, I would say, the center pivot of every intention is the statute itself, the text itself. Every intention must go around. That's why I used the first that it cannot escape the circumscribed limits provided by the text. The text provides the limits, it is the pivot around which the intention can revolve. The doctrine of this equity follows law, as I talked about it at the inception, is talks about the same thing. It's not the basic intention of the may not be. I won't say it is not. I say it may not be the basic intention of the framers of the law or the makers of the law. It may be at the time of just the judge, what he just perceives of a particular so far as this particular set of facts are involved in a particular case. He may feel it differently at the time. The application must be in a different way. That's why a latitude has been given to the judicial officers regarding the demeanor of the parties. They must know the demeanor of the parties before the honorable courts, how they appear, how they talk, what experiences a judge gets. That's why one of the provisions in CPC is the interrogatories. They talk about the questioning of litigants, so that a judge gets feel about the case, what the case actually really is and actually is, and what are the actual facts involved, and to see the purpose and how I apply that purpose to this particular fact is the duty cast upon the judicial officer. It comes boils down to the judicial wisdom of a judicial officer then. And when I talk about the judicial wisdom of a judicial officer, I immensely press upon the fact that it is the advocates who assist the honorable judicial officers to come to a particular conclusion. The duty, the main purpose, and the duty is cast upon an advocate. How he perceives, how he feels that these set of principles will apply to my case in a different manner, and that in that context he may just try to just convince the judge that this is and ultimate duty is cast upon the judge, because he is the umpire to see both the sides and to get an idea of the case, and then he will deliver accordingly as per the intention. May or may not be the only of the lawmakers. It may be the intention of the judge, the intention of a lawyer, and the intention of the parties. This is very important, and the circumstances, social circumstances, and the social setup in which the law is applied. Hope I have answered your question.
Okay, sir. Okay, sir. Now we take our next question. Mr. Mansab Shafi Wadu has raised his hand. Mansab, please ask your question.
With immense pleasure.
Mr. Mansab, please ask your question. Okay, I think
Assalamualaikum
Mr.
and a very
Wasim.
good
Yes. Good evening. Good evening.
Assalamualaikum and a very good evening, sir.
Walaikum salam.
First of all, I would like to thank the Codecast team that they are enlightening us on every weekend with such a big shorts. So I'm immensely thankful to the Codecast team. Now, as far as the elaboration done by the today's guest is done, I would love to get the answers for certain queries, if I may be allowed.
Yes, so please go ahead.
Sir, in the daily practice of law, the most important subject is the construction of documents as explained and elaborated by you with the best of your abilities. Yet it is the subject on which the opinions are still much divided. There are the strict constructionists on the one hand and the intention seekers on the another hand, as far as the Department of Law, Justice and Parliamentary Affairs is concerned. The intention seekers go by the purpose or intent of the makers of it. Sir, now my concern is that as far as you explain the law and text, and many of your wordings were dealing with the English law, as per the mandate of English law, I believe they stood by the golden rule laid down by the House of Lords long way back, whereby the Lord Chancellor there said that the courts should adhere as rigidly as possible to the expressed words that are found and to give those words their natural and ordinary meaning. My
Exactly.
concern is that one of the finest justices of our country, Justice Markande Karju, long way back texted in one of the finest judgments that law is harsh, but law is law. Kindly enlighten all of us, sir, regarding this text mandated and sealed under the hands of one of the finest judges of the country that law is harsh and law is law. How should we take this as text in the Department of Law, Justice, and Parliamentary Affairs, sir?
Exactly. Yes, indeed. And I was talking about this issue. Basically, how differently the parties sometimes feel that in its application, the courts have not done justice to them. But once the rules are being set by a particular text of the law, they are to be applied as such. There is no escape. I was talking about the text is the main pivot, just around which the purpose of it can revolve, but it cannot escape the pivot. It cannot escape the bounds. That's why it is being said, just but there at the same time there have been so many judicial officers of our honorable Supreme Court who have said that so far as the substantive justice between the parties is concerned, the judicial officer should not, just seldom, just feel, just restricted in their application of law to a particular set of cases. The duty is cast. Justice Krishna Iyer, for that matter, has just in one of his judgments has profoundly emphasized on this fact that it is a duty. Just why the courts are being respected throughout India is for the matter that not they are not just stricter in their application of law, and they do not go by the plain meaning of it. Rather than they try to do the substantial justice between the parties. They do not gut themselves into the intricacies of law. Rather than they try to bring the parties together and try to resolve the matter so as the substantive justice is concerned. That's what I mean to say. But at the same time, let me talk about it once more time. As Lincoln has in one of his speeches said that law is law till it is being set aside by the howsoever it may be, it's ugly. One is bound by it. One is bound by the peripheries of it. So far as it is not being declared as ultra virus by the courts, it is to be followed, or it is being set aside. The law, there is no escape from the contours of law in its application to the masses. That if that concept just that concept basically governs so many social aspects of our society. The litigants do not feel at the same time, they do not feel that differently, they can be differently governed at different times in different cases. Rather than, if somebody commits a sin or commits a theft, he knows what is the punishment of the theft and how, what law talks about the theft. So in its application, law has its uniformity, law is structural, law is text, but at the same time, it is duty cast upon the honorable judges to do the substantial justice between the parties. Hope I have answered your questions.
Absolutely correct, sir. Thank you so much for your wise answer.
Gracious. Any more questions?
Yes, sir. I think we have a question from Mr. Wasim. Mr. Wasim Shams will ask the next question.
My question is with regard to negotiable instrument. We have negotiable instrument for chuck cases,
Mhm.
right, sir? But we cannot invoke jurisdiction of civil court. But
Yes.
last year, I saw that you have filed a civil suit wherein you had challenged the chuck, and fortunately, you had got a stay from first month. Thereafter, appeal was going on in
Yes.
PDJ. I
Yes.
mean, how is that possible? Once you have a civil right, simultaneously there is a criminal statute.
Exactly.
I would
And
like to
I
know,
think
sir.
you,
Thanks.
there was different set of grounds involved. I took different set of just facts involved are involved in that case. Particularly, the matrix behind that case was that the person who signed those checks was telling me that basically they were given as part of the negotiations. A contract was made between them. The person against whom the case was filed was a money lender. He lended him money and he charged him interest to so much exorbitant rates, at so much exorbitant rates, that the person was threatened by the money lender that to give us some security in form of checks and legal documents, Hondi and all that. I filed a case that this cannot be, just there is a concept in law that interests cannot be penal in nature. One of the grounds was that in interests cannot be, just one cannot, just put you this more interest on you than the nationalized banks. How they charge the interest, the scheme has to go, go by that. When we do, once we do the affairs of a state, or once we handle the affairs of this money, the basic this rules governing the interest, or what can be the rates of interest, is being governed by the RBI, and the rates are there. On the rates, the nationalized banks charge the interest from their consumers. They can charge them. A private money lender can charge accordingly, but he cannot penalize or punish this gentleman just for the reason that he has approached him for a certain loan, and just charged him so much exorbitantly. And that plea was considered in light of few judgments and legal aspects of that very case involved, just facts involved in that very case.
Sir, we have another question from a senior lawyer, Mr. Bashir Ahmed Shah. I would
Sir,
invite him to
with
ask the
immense pleasure.
question, please.
With immense pleasure, sir.
Mr. Shah, please ask your question. Oh, I think we have lost him, sir. So,
No, please.
all right, sir. So, lastly, sir, I would like to thank you for this wonderful lecture. This probably was our first lecture, which was completely theoretical in nature, and we hope
Yes.
that because having theoretical lectures is our first preference as well. The reason being that it forces you to think outside the box and go out of one's comfort
Out of the
zone
box.
to yes, sir, to think of abstract ideas behind laws, and then we can go down the level of abstraction. We can pull down the level of abstraction to practicality. So thank you once again for initiating and pioneering such a wonderful initiative, sir.
And
And
I'm really
lastly
thankful to
on
you
yes, sir.
and your team that I have been given this opportunity to just talk or confabulate rather. I won't
Yes, sir.
use the giving lectures. I cannot give lectures to lawyers. I can rather confabulate. We can rather confabulate on a particular issue. We talked
Yes,
about
sir.
it
So
with immense pleasure.
that is the idea behind Codecast, sir. It's a knowledge bank. This lecture series is a knowledge bank. So
Indeed.
whoever we feel can contribute to it, we share our knowledge and they accordingly share it with other members as well. And it has been a very good, very successful lecture today, sir. We hope we'll have you here sometime, some other time as well on some other important topic. And I would also
Inshallah.
like to thank all the participants who have stayed with us for this long. And thank you once again. And we hope to see you next week. Thank you.
Thank you, sir.
Thank you, sir.